So, good afternoon. My name is David Sehnálek. I teach at the Faculty of Law, Masaryk University, and my specialization is EU law. The topic of today's lecture is legal and judicial reasoning. And I came to this topic thanks to my research within the Central European Professors Network, coordinated by the Ferenc Mádl Institute of Comparative Law. Today's lecture will have two parts. One, rather general, focused on needs of someone who wants to write a persuasive and well-reasoned legal text. The second will be focused on the style of reasoning by the Court of Justice, European Court of Human Rights, and the Czech Constitutional Court. Please mind that the lecture is recorded and will be published online, so you will have access to it later. And whatever you do will be made public and stay public forever. So since you have been warned, we can start. We lawyers work primarily with words. We use them like magicians. They have the power to shape the world, to change it, as with our words we influence minds and decisions of others. The right words can help us. The wrong formula can hurt and cause damage to us, to our clients, or to other people in general. We have to be very careful about what we say, what we write, and also when we do it. For example, when we negotiate a contract or when we write a submission to a court, the right timing often does matter. Words and ideas must be put together appropriately. The magic formula will not work unless a certain order is followed. Certain words have more power in them than the others, so good knowledge of the language also matters. To use words well, we must know them, and we must be able to interpret them. We must be able to use them correctly. A good lawyer must be able to carry out the research, must analyze complex problems well, and above all, must be able to explain his ideas, and he or she must do it in a simple, clear, and convincing way to the addressee of his message. Words are our weapons, but we should use them wisely. That is why it is not true that quantity is better than quality. On the contrary, a good lawyer writes clearly, concisely, and precisely, and this is the rule. The truth is that in practice you might find yourself having to write extensive analysis over many pages of the text. Thus you will be in situations when you have to breach this general rule. This will be the case in law firms where you'll be writing opinions for your clients, as such practice will allow you to charge fees for your work that are commensurate with the know-how you put into your work. Only a few are willing to pay large sums for a few-page analysis. Because if you are going to charge clients reasonable amounts, they need to see that it is for some tangible result of your work. And in such a case, the rule, the less is more, of course, doesn't apply. And there is one other exception I must mention, and that is the situation where the case you are litigating in court is clearly lost. Then your last chance may be to confuse the judge by long statements that are hard to understand, so much that he doesn't feel confident about his or her decision. For today, let's forget those two exceptions, and let's have a look on how to do things right. And well, back to the rule. I will believe that it will be easy to remember, as its acronym is KISS, which means keep it short and simple. It is a design principle which states that your text should be as simple as possible. Most of our writing aims either to predict something or to persuade someone. Both of these types require a certain ability to explain legal rules and legal concepts. The first predictive group includes situations where a client comes to us, describes a certain problem that is bothering him, and then wants to know the solution. It also includes situations where we have to prevent the problem. For example, we are given a contract and have to analyze it, and our job is to figure out which parts are problematic, where the risks are, and how to adjust everything to make it right. The second group includes those situations where we need to convince someone that a certain conclusion and decision is the right one. We might be trying, for example, to persuade a judge to issue a desired decision, or the opposing party to comply. Predictive writing is characterized by a high degree of objectivity. You must view situations through the eyes of your client and through the eyes of the opposing party. You must propose a strong and persuasive solution, but you must equally point out any risks and weaknesses in your argument. Otherwise, you risk your reputation and, of course, your money. Remember, as a lawyer, you are responsible for your advice, and your client has the right to know both the information that is in his favor, but also all the potential risks. In the case of persuasive writing, things are a little different. First and foremost, you must distinguish who you are writing to. Who is the addressee of your text? It may be the judge, but it also may be your client's client or the other person with whom your client is in a dispute. And there is a big difference between the two. You have no superior position vis-à-vis the judge, but you may have one vis-à-vis your client's client. And you must choose the style and the language you use accordingly. In addition to that, you will write differently to someone with whom you have no interest in continuing to work with. And you will choose different words when there is an interest in maintaining cooperation, and this interest is your priority. For example, if you are going to write to your client's debtor to make a payment, knowing that your client won't do any business with the debtor in future, you might choose a clear and straightforward style of writing, and a confident, passive-aggressive style can sometimes help. You will need to work with the facts and with the law, but you most likely will not be expected to explain these facts or the law in detail, and you will not be expected to do any in-depth analysis. The style will be concise, simple, and clear. You'll be explaining clearly what you want, why, and what the consequences will be if you don't get it. On the contrary, if you are communicating with someone you don't want to lose, you will choose a softer expression, a more sensitive approach, but the level of argument will be most likely quite similar. But if you are addressing the court, you will need to take a different approach, one that reflects its authority and different positions towards you and towards your client. Your argumentation will have to be objective and more detailed. And remember, it is you who knows the case and the law, not the judge. So you have to prepare things for the judge in the best possible way from the perspective of your client. You have to do the job for the judge. In all cases of persuasive writing, however, your ability to get your strategy right will be crucial. What you write and what not to write is a key. What to emphasize and what to mention. In what order you will present your arguments. Your persuasiveness will be the key. And although it may not seem like something likely and useful, your ability to tell stories and play on emotions might also have a significant effect. Remember, too, that your goal should never be to take a case to a trial. Going to a court means that you have lost. Even winning in a court is a draw in most cases. A good lawyer can resolve problems without going to a court. This is because litigation involves uncertainty. You never know what the decisions will look like. Negative emotions on your client's part, on your part. It involves costs, unnecessary cost, and most importantly, it's really wasted time. You want to avoid litigation if at all possible. If it is not possible, then go and fight. We talk about predictive writing and persuasive writing. And I think that the problem with Czech law schools is that our students are trained pretty well in the former, in the predictive writing. In practice, however, you will need both. And the lack of knowledge of persuasive writing will be a problem. Well, the good news is that this is true in general in case of all the absolvents of all our law schools. There is no difference between Prague, Olomouc, Plzeň, or Brno. So it is safe to say that you most likely won't be an exception. For it is true that law schools students are not taught to write well and persuasively. Therefore, they must learn it themselves by practice. And you are law students, so therefore it is true that you will have to learn to write well on your own by practice. Well, the reason why I formulated my initial conclusions in this way was not to offend you in any way. The reason is different. It is because we are getting to the way we solve legal problems. In fact, lawyers have developed certain mechanisms and reasoning schemes that help them analyze their clients' problems, solve them, and convince a court or an opposing party that a position is strong and persuasive. Judges use these mechanisms as well, and they use them in order to explain and justify their decisions. And knowing these mechanisms is both useful and necessary, so let's have a look on them. There are two basic methods of reasoning used by US lawyers. And this is the deductive and inductive reasoning. And let me repeat once again what I have said just a minute ago. Czech law students are not taught to write well and persuasively. Therefore, they must learn it themselves by practice. You are law students. Therefore, it is true that you will have to learn to write well on your own by practice. This is an example of the deductive reasoning. It is a rule-based reasoning where you move from general to specific. And it is the most common type of reasoning in both US as well as here in Europe. Deductive method is applied in reasoning from statutes, which form a rule of general application under which specific facts of your case may fall. And deductive reasoning has two main steps. First, you have to identify the general rule. To put it simply, to identify the statute and a relevant provision. And second, to apply the rule to a specific situation, to the facts of the case. And the reason why you do it is that it allows you to predict the likely outcome or to establish this outcome. A classic example of this method of reasoning is the one with Socrates. Major premise here is that all men are mortal. Minor premise is that Socrates is a man. The conclusion is, therefore, Socrates is mortal. As we are lawyers, we shall focus on legal reasonings. Let's have an example of legal reasoning. Article 34 of the Treaty on the Functioning of the European Union and the case Dassonville prohibits all quotas and measures having equivalent effect, limiting the trade with goods in the European Union. That's a major premise. Import licenses are measures having equivalent effect. Therefore, that's the minor premise. And therefore, import licenses are prohibited. And that's the conclusion. So let's have a look on this diagram. First, there is a major premise, which is a general statement that is known to be true. Second, there is a minor premise, which is another statement we also know to be true, which engages with the smaller category of the major premise and the specific case at hand. And the third step allows us to take what is known from the first two premises and conclude something new about the case, which is that it fits within the largest category. And the circles of this diagram represent how the categories fit together in deductive reasoning. B fits within the A. The minor premise fits within the major premise. And C fits within the B. So the conclusion fits within the minor premise. So the conclusion or the specific case must also fit within the A, within the major premise. And the advantage of this reasoning is that the logic in this form of reasoning is certain. In other words, the result we obtain is always correct. And this is something that makes this method different from the inductive reasoning, which we'll see later. Well, it looks easy, right? Unfortunately, the practice is much harder. First problem is that it may be hard to correctly identify and interpret the rule. And as a result, the major premise is either incorrect or is fully missing. Another problem is that this method of reasoning requires certain ability to distinguish important facts from background static and to recognize when those facts would require treatment under a general proposition. In law, we refer to those important facts as material facts, facts which matter. Another problem is that a minor premise might be wrong or missing. The text which you produce contains just the law and the conclusion, but nothing in between. And this is, by the way, quite common mistake I see that my students are doing, and sometimes even experienced lawyers do the same mistake. You can quite often read a paper or a submission which contains excellent textbook-like analysis of a certain problem or a certain regulation, and then suddenly comes the conclusion, and there is nothing in between. I have read such seminar paper 2 weeks ago. I set my students the task of assessing a very specific problem concerning the freedom of movement of goods. And the answer my students produced was perfect. It was a perfect description of the rule contained in Dawsonville case. They also produced and mentioned all the subsequent evolution of the case law related to the Dawsonville case and to the Article 34. And then suddenly came a conclusion where the students said, therefore, such a measure by a member state is an obstacle to the movement of goods and as such is prohibited. And that was it. No explanation, nothing at all. So let me give you some examples. I have already mentioned the situation where the minor premise is missing. You mentioned just the law, just the rule, and the conclusion, and there is nothing in between. And another example where the deductive method was not deployed well is the following text, which you can see in italics on this slide. It is rather difficult to read. Well, I have tried to preserve the original text as much as possible. At the same time, the Czech text was already quite difficult to read. And by the way, it was written by a Czech activistic lawyer who fights against all the government restrictions on COVID. Well, and the text states, I'm informing you that the fact that my child is being discriminated by being denied the constitutional protected right to education, and by the fact that she has been ordered to be quarantined after contact with a person who has been tested positive on the grounds that he or she is not vaccinated with a voluntary vaccine, I consider it to be unjustified discrimination and a serious violation of constitutionally guaranteed equality of citizens. Well, and where's the problem? Well, here the major premise is missing. The submission contains just a minor premise and a conclusion, and as such is insufficient since we completely lack the rule, and it's even a short explanation. In practice, lawyers need to apply more detailed structure of reasoning. And quite common methodology for legal analysis and writing is the one known under the abbreviation IRAC, which stands for issue, rule, analysis, or sometimes application and conclusion. The issue is simply a legal question that must be answered, or a description of a problem you are trying to solve. It is a part where you state the legal issue that will be discussed, where you specify the core of the problem. Then, in your text, should be present the rule part, and this part follows the statement of the issue at hand. And in our legal culture, the rules usually derive from statutes and past cases. In case of the Constitutional Court, Court of Justice, and European Court of Human Rights, the role of case law is more significant compared to the ordinary or common courts. And it is true that in many aspects, the work of these courts resembles the way the US courts work. The third section, Section A, applies the rules developed in the rules section to the specific facts of the issue at hand. It is important in this section to explain or argue why a particular rule applies or does not apply in the case presented. The analysis section is the most important section of an IRAC, because it develops the answer to the issue at hand. And in the section conclusion, there is a place for the most likely conclusions using the logic of the application section. Well, and it is true that IREC works well also for courts and their decisions. If you work with decisions of the European Court of Human Rights or the Czech Constitutional Court, you can clearly see this pattern. And should you write a submission to the court, you may want to adopt a slightly modified approach, which is known as CREAG. So you can see that the first letter I is replaced with C, and the C here stands again for conclusion. So in this case, you are doing something a reader of a detective novel wouldn't like you for. You tell him right at the beginning that it was the gardener who was the murderer. But it's absolutely okay in law, as this approach offers more clarity. At the beginning, you simply and briefly state where you want to go, and this allows the reader or listener to follow the logic of your reasoning and thoughts in the following steps. At the same time, such a text is clearer and more convincing. Once you read or listen one thing twice, the chance that you accept it and remember it significantly rises. Well, and let me give you some examples. This is an example which concerns a case solved by the Czech Constitutional Court. Czech Republic, similarly to Hungary, prohibited registered partners from adopting a child. The relevant legislation was contained in the Civil Code and in the Act on Registered Partnership. Czech Civil Code allows the adoption only in case of married couple. There is, however, an exemption from this rule, which allows the adoption by another person. In other words, not by a couple, but also by an individual. The Civil Code also does not explicitly exclude an interpretation of the term other person in such a way which includes also a registered partner. However, it is the Act on Registered Partnership which contains a strict prohibition of this possibility. You can see the text of both relevant provisions on this slide. And as a result, Czech legislator allowed the adoption of a child by an individual who does not live in a marriage. And the fact that he or she is a person of heterosexual or homosexual orientation is absolutely irrelevant. On the other hand, at the same time, the legislator prohibits this individual from living in a registered partnership, which is legal. So you could become a parent de facto, but not de jure. And this is really, illogical. So let's have a look on the possible argumentation in this case using the IREC and CREAG little simplified pattern. IREC style of reasoning would look like this. The law prohibits adoption by registered partners. It does, however, allow it to other individuals, whether single or married. The only distinguishing criterion is therefore sexual orientation. Charter, meaning Czech Charter of Fundamental Rights, however, considers such a distinction to be prohibited discrimination. Therefore, adoption should be allowed even to registered partners. The legal prohibition of adoption by registered partners is therefore unconstitutional because of its conflict with the prohibition of discrimination. So this is the application of the IREC structure. And let's compare it with Czech style. Czech style reasoning would look like this. The ban of adoption by registered partners is unconstitutional. The Charter prohibits discrimination on the basis of sexual orientation to preserve equality of opportunity and equality of outcome for men and women, regardless of their orientation. If the law prohibits adoption by registered domestic partners and permits it to all other individuals, regardless of whether they are single or married, the only distinguishing criterion is sexual orientation. Prohibition of adoption by registered partners is therefore unconstitutional. In the second part of my lecture, I will focus on interpretation of statutes. It is indeed necessary for a lawyer to master the art of interpretation, since mistakes usually occur in the first major premise where the rule is set. So I said previously that the most important part is the A part. However, if you try to discuss the text which was prepared, for example, by, or issued by a court, if you are trying to appeal against a decision of a court, or if you react on a submission of the opposite party, then you really want to focus on the R part. I mentioned that there are two basic methods of reasoning. Another method of reasoning is an inductive reasoning. And this is a method that involves reasoning from specific examples to propose a general rule. This is something that is not typical for European legal practice, I would say, but let's first demonstrate it. Imagine that you have a black opaque box. So you can't see what is inside of this box. And this box is full of balloons you can't see. And you pull the first one out, and you see that it is yellow. Later, you pull the second one out. It's yellow again. The third is yellow as well, and the fourth is also yellow. So what color would you expect to pull out on the fifth try? Well, I guess yellow again, of course. The slight problem is that it may or may not work. The fact that you have drawn 4 yellow balloons only indicates the possibility of the existence of the rule that all balloons in the black box are yellow. It's not a certainty, though. You wouldn't want to apply this way of thinking while gaming in casino and playing roulette, since the fifth ball could be very well red, and we won't know it until we pull it out. So this form of reasoning is therefore not bulletproof compared to the previous one. It is also quite common that a single case will not set every legal rule for a given area of law. This is so in particular because of the fact that some rules may not be relevant for the case at hand. Therefore, in order to be able to state the law or rule completely, a lawyer must deploy a process called rule synthesis. In Europe, we follow a slightly different approach, usually. What they do in the United States, when they are trying to synthesize the rule, might seem strange to us, since we usually start from a general rule, which we can find in a statute. We then interpret it and thus make it specific. And this allows us to apply it subsequently to a specific case. So from our point of view, it looks like that our US colleagues, when they are trying to synthesize the rule, the judges are making up the rules. But the truth is that they are not. They are just identifying them. So in practice, that means that the rule already exists. They just have to be identified. And the process is like a jigsaw puzzle. Well, and the problem is that, you know jigsaw puzzle games. And the problem is that in most games of this type, you have all the pieces available in one box. And your task is just to put them together. Unfortunately, as a lawyer, you wouldn't have usually such help. So you will have to find all the pieces by yourself. You will have to not only put the jigsaw puzzle together by yourself, but you will have to first find these small pieces. From a practical perspective, I would say that you can either consult textbooks, jurisprudence, or quite good approach is to find the latest decision of a specific court available and hope and pray that it contains a summary of all previous decisions related to the topic at hand. In case of the Court of Justice, the opinion of Advocate General often helps, as these opinions often contain a very detailed analysis of the decisions that have been issued so far on a given legal issue. So it is the Advocate General who does the work for you and collects all the pieces of the puzzle into one box. And I've said that this process is typical in the United States, but you can also find it in Europe. It is characteristic for those areas of law that are made of very general rules. Thus, it is common. For example, in case of human rights or constitutional matters in general. And it is also quite typical in the field of the European Union law, but only in relation to the primary law, as the founding treaties of the European Union are also rather framework. They use broad terms, and the provisions are rather general. In the case of the decisions of the Czech Constitutional Court, the likelihood that the ball which you draw from the box, that it will be yellow, is strengthened by the fact that this court is bound by its own decisions. So while these decisions are not a source of law or a precedent, it is reasonable to assume that the court will rule the same way in the future in a factually and legally similar case, as it is quite hard for the Constitutional Court to change its case law. And in addition to that, the fact that the ball will be yellow is also true in those cases where the Czech Constitutional Court works with decisions of the European Court of Human Rights and Court of Justice. But it's true more in case of decisions of the Court of Human Rights. Since our Constitutional Court also feels bound by all decisions of the European Court of Human Rights, and not just by those addressed to the Czech Republic. So the decisions of this court are sort of de facto precedents in the Czech Republic. And the same is expected from common courts in the Czech Republic. So, to demonstrate the process of synthesizing the rule, let's have a look on the case law of the Court of Justice related to the EU citizenship. The general rule is contained in Article 20 of the Treaty on Functioning of the European Union. According to this provision, according to Article 20, a citizenship of the European Union is hereby established. Every person holding the nationality of a member state shall be a citizen of the Union. Citizenship of the Union shall be additional to and not replace national citizenship. So here we have quite clear rule. The problem is whether a right of residence for a third country national can be derived from the EU law also in a situation where his family member, who is an EU citizen, has not moved to another member state. So imagine a Czech man who marries a woman, for example, of Russian nationality. They have a baby together here in the Czech Republic, who becomes also a Czech national. Well, and the question is here whether the right of residence for this third country national, or this Russian spouse, can be derived from the provision of Article 20 of the Treaty on Functioning of the European Union. And apparently there is no guidance in the wording of this provision. Nevertheless, in case Zambrano, the Court of Justice allowed 2 Colombian nationals to live and work in Belgium in order to facilitate Belgian national children living in Belgium. The Court of Justice said, Article 20 is to be interpreted as meaning that it precludes a member state from refusing a third country national upon whom his minor children, who are EU citizens, are dependent, a right of residence in the member state of residence and nationality of those children, and from refusing to grant a work permit to the third country national, insofar as the decisions deprive those children of the genuine enjoyment of the substance of the rights attaching to the status of EU citizen. So, based on this decision, the possibility of a third country national who is a family, who is a relative to a family member who is an EU citizen and has not moved to another member state was established. This was something that was not written anywhere in founding treaties of the European Union, and the provisions of European Citizens Directive 2004/38, didn't regulate this issue, so they were not applicable. So the Court of Justice interpreted the Article 20 very broadly. In a subsequent case, McCarthy, the Court of Justice somehow shaped its former decision. It dealt with a situation of dual Irish-British national born who was living in the United Kingdom. So he had both the Irish and British nationality, but lived in the United Kingdom, where he was born. And this national relied on state benefits. And she was married to a Jamaican national who was not allowed to remain in the United Kingdom. And they had applied for a residence permit for him on the basis of his status as the spouse of an EU national. So the situation was somehow similar to previous case Zambrano. But contrary to the decision in Zambrano, the court found that Ms. McCarthy and her spouse could not rely on EU law. So the facts of the case were similar. However, the difference was that Ms. McCarthy was not dependent on her non-EU spouse to remain in the United Kingdom as an adult. This rule was further shaped in case Derechi. The case of Derechi concerned several families where third country nationals wished to join family members in Austria. And these family members were all Austrian citizens. So again, third country national, an aesthetic citizen who is not moving to another member state of the European Union. Excuse me. The main issue in the case was the extent to which the case Zambrano applies to the situation. I beg your pardon. And the court said that it follows that the criterion relating to the denial of the genuine enjoyment of the substance of the rights conferred by virtue of EU citizen status refers to situations in which the Union citizen has, in fact, to leave not only the territory of a member state of which he is a national, but also the territory of the Union as a whole. So again, contrary to Zambrano case, here the outcome was not favorable for the people concerned. Subsequent case was case Chavez and Wilches. This concerned a Southern American national who had a baby with Netherlands national, and the baby too had Netherlands nationality. And later, the Southern American national and her child were compelled to leave the family home. Netherlands authorities refused to grant her social assistance and the child benefits. And the application was rejected on the ground that since the parties did not have a right of residence, they did not have any right to receive such assistance and benefits. And the main argument from the viewpoint of EU law was that the baby could live with her or with the father. So there was an option, and the baby, the possibility of the Southern American to stay in EU was not allowed. The baby still could live in the European Union, in Netherlands, with his or her father. And here you can see what the Court of Justice said in this case. The Court of Justice said that the fact that the other parent, who is a Union citizen, is actually able and willing to assume sole responsibility for the primary day-to-day care of the child is a relevant factor. But it is not in itself a sufficient ground for a conclusion that there is not, between the third country national parent and the child, such a relationship of dependency that the child would indeed be so compelled where there to be such a refusal of a right of residence. And finally, there was a case, a Spanish case, which concerned a Moroccan national of full age who married a Spanish national of full age in Spain. None of them had any income, and Spanish authorities rejected his application for a temporary residence card in Spain on the grounds that his wife hadn't shown that she had sufficient financial resources to cover their needs. Nevertheless, the father of the Spanish national undertook to cover the costs resulting from his stay in Spain, and this was not taken into the account, not at all. Well, and what the court said, you can see on this slide. From the answer, it is apparent that the condition of sufficient resources may not be decisive, despite the fact that in order to be able to live as a moving citizen in another member state, you must have sufficient resources, as this is a condition set by the Citizens Directive. It is a prerequisite for a long-term stay in other member state of the European Union. But it may not be a decisive factor in case of Article 20 of the Treaty on Functioning of the European Union and in case of a static EU citizen. But we are not here to discuss the right of residence of EU citizens in the European Union. That was not my point. That was not the goal of these slides you have seen already. The idea should be different. My point is different. We have now several decisions concerning a similar problem. When we take them together, we are in fact collecting all the relevant rules. So we have to first collect them, and now we have to analyze them and put them together so they create a logical, complex rule that can be applied to a new case. And apparently, the meaning of the article of the Article 20 of the Treaty on Functioning of the European Union is way broader than it may seem from its text. It may be a basis for residence rights for third country nationals. And apparently, this extends not only to children and their parents, but also to other relatives. However, there are some conditions that have to be fulfilled. Well, and sufficient resources do not belong among these that would be compulsory. So in this way, you synthesize a rule that can be applied to a subsequent new situations. And practical point, the tricky part here is that Court of Justice of the European Union sometimes changes its case law, and it does so silently. It renders a new decision without mentioning previous decisions and stating that the approach, the rule developed and applied differs from the past cases. So that's a thing that, is kind of tricky. Another quite common type of reasoning is a reasoning by analogy. Reasoning by analogy involves drawing specific conclusions from other specific examples based on similarities between them. And this approach is related to the principle of non-discrimination. There is a rule: do not treat similar situations differently, unless the difference in treatment is objectively justified. Using analogy may nevertheless be tricky, as it may be hard to identify similarities or differences correctly. Imagine following situation. Let's, play with third country nationals again. A third country national marries an EU citizen. They have a baby together who is also an EU citizen. And they never move to another member state as they live in the domestic state. So it is a situation of Czech husband, Russian wife, and Czech child. And later, the couple divorce. And the question is, can the third country national base his residence rights on EU Citizens' Rights Directive? So we are now not discussing the Article 20. We have seen that there is such possibility under certain circumstances. But the European Union law regulates the rights of family members also by the Citizens' Rights Directive. Nevertheless, this directive grants EU citizens who moves to another member state a right of residence there, and this right extends also to the spouses and children. So this directive concerns only not static citizens and third country nationals, but those EU citizens who actually move first to another member state in order to reside there. And the situation is quite similar to our case, to the facts of our case. The difference is only that the family, in our case, doesn't exist anymore, at least between the spouses. And another difference is that, no one has moved to any other member state. So the directive codifies rights of moving citizens, whereas our situation concerns a static citizen. And his rights are not codified by EU law at all, except, save for the exemption we have seen on the case law related to the Article 20 of the Treaty on Functioning of the European Union. So, from this perspective, the analogical application of the directive might represent a chance for this father, a third country national, how to establish a residence in the Czech Republic. We will apply the rules which were developed for moving citizens and their families, similarly to situations which concerns people living in one state and not moving anywhere. And the question is it possible? Well, there are similarities. He or she is an ex-spouse, a father to the child who is an EU citizen, or a mother to it. On the other hand, the difference here is that there was no movement to another member state. So which should prevail? Well, and in this particular case, the analogy wouldn't work. It is not possible. As should be the situation of similar difference in treatment is objectively justified, because moving citizens have codified rights by the directive, whereas non-moving citizens in principle derive rights from national law, the member states. And this area, this regulation is completely out of the competence of the European Union at the moment. Well, so that's against the possibility to apply the analogy. And should be these situations different, because of the difference between moving and static, well then of course also the legal solution must be different, and as a result there is no place for analogy at all, despite the fact that it may be an easy solution of the problem. I will also give you an example of a successful application of analogy, and let's have a look on a case CS. It is a case of the Court of Justice. And this case also concerned a third country national who was a mother of a young child. This child is a Union citizen living in the state of his or her citizenship. And his mother committed a crime for which she was expelled from the territory of the United Kingdom, the state where they lived, to a third country. So apparently, this case is very similar to the Zambrano case, where the Court of Justice said that there is a possibility, to establish a right of residence even for a third country national who is related to a non-moving to a static EU citizen. And what is the problem here? So the United Kingdom tried to expel this person from the territory of the state. Well, and should it be a case of moving EU citizen, such approach would be completely legal it would be fully in accordance with the EU law. Since in case of moving EU citizens, their rights are codified by the directive, Citizens' Right Directive, and so are codified all possible limitations. And one of the possible limitations is that, you know, a person may be expelled if he represents a danger to a public order or public security. So the conditions when they can be expelled are strictly set. In case of static EU citizens, such a regulation is completely missing. We have just, which you have seen already, the Article 24, you have seen that already, and the case law, Zambrano, Derechi, McCarthy, and other related to it. So there are no limitations to this right of residence at all, are not written anywhere, which is somehow strange. In one case, the member state may protect its vital interests, it may protect its public order, and in the other not. You know? And when we look on these situations objectively, they are similar. And you know, the solution of the Court of Justice, you can see it on this slide. The Court of Justice applied limitations known to the law regulating right of moving citizens by analogy, with the results you can see on the slide. The Court of Justice said that in exceptional circumstances, a member state may adopt an expulsion measure provided that it is founded on the personal conduct of the third country national, which must constitute a genuine, present, and sufficiently serious threat, adversely affecting one of the fundamental interests of the society of that member states. This is exactly the principle, the limitation, which is codified in case of moving citizens, and it was extended by analogy to the Article 20 and the rights of static EU citizens and their family members. So again, it's a, you know, we are building up the case law, creating the rule, and here again we have somehow additionally shaped the original Zambrano formula, Zambrano case, and here by analogical application of another piece of EU legislation. Well, and now let's have a more detailed look on judicial reasoning. There is a significant difference between submissions of attorney at law and judgments. The first may be subjective, as there almost never is the one right answer to a legal problem, to a legal issue. Remember that good argument can be made for both sides, and good lawyer does choose those which suits his clients the best. These submissions may contain extra legal arguments. I refer to it as telling the story, you know, the story which is convincing. I guess that you all remember Shrek movie and the look of Puss in Boots. Well, and it really, really works. Judges have emotions and personal beliefs that can affect their decisions, and you need to have them, you know, judges on your side. You need not only convince them by your legal argumentation, but also win their hearts. On the contrary, judicial decisions are often written in the language of objectivity and at pains to show that conclusions are based on legal principles and logical arguments, rather than choices and extra-legal factors. And indeed, within my research, I haven't found a single decision of the European Court of Human Rights, Court of Justice, or Constitutional Court in which any of these courts would base its argumentation mainly on extra-legal factors. So let's have a look now on the way these three courts usually argue, which brings us back to the IREC and CREAC structure. Since I said already that important part of legal reasoning process is the one in which the rule is established. In civil law countries, it is a general rule in a statute where we have to start. So you have to identify a proper statute, which is relevant to your case, and relevant provisions. And then we have to deploy certain methods and arguments in order to further develop this rule and in order to be able to apply such extended rule on a specific case. This process, to a certain limited extent, resembles the synthesis known to common law, which is applied within one single case. This may happen where the judgment does not directly state the legal rule, just the facts and the conclusions. So you have to reconstruct and formulate this rule if you want to apply such case to a subsequent case. And we are doing here something similar. And the question for the rest of this lecture is how do we develop the rule? So we are now focusing on the R section of our IREC schema. And I believe that methods and arguments that are typically used by civil law courts are not unknown to you. They use grammatical interpretation, logical arguments, domestic systemic arguments. They base their interpretation on the basis of case law. They may base their interpretation on international treaties. They may utilize a case law of international forums. Czech Constitutional Court typically uses decisions of the European Court of Human Rights or Court of Justice sometimes. Our courts usually or typically use comparative law arguments. Teleological interpretation is another method. Sometimes subjective teleological interpretation may help in order to properly interpret and develop the rule. Some courts use argumentation which is based on jurisprudence. Sometimes it is necessary to deploy the interpretation in light of general principles, and sometimes you even play with non-legal arguments. These methods, however, may be deployed differently by various courts, as well as in various jurisdictions. Some may put an emphasis on grammatical method of interpretation. Some may prefer purposive interpretation. Some take into the account the jurisprudence and some not. So thus, the courts are using pretty much the same methodology in the reasoning, but the mix varies. And as a result, outcomes of the work of these courts may also be different. I was doing within my research and analysis only in the area of fundamental rights and freedoms. So now I will focus on the work of Constitutional Court, and I will compare it with the work of Court of Justice and European Court of Human Rights. And one would expect that grammatical method of interpretation would be the one which prevails in courts in judicial reasoning. But if you look, for example, on the Czech Constitutional Court, we can say that this court uses the grammatical method of interpretation only to a limited extent, at least in the area of fundamental rights, which is different from cases related to state organization issues, where this method of interpretation plays a more significant role. So this method is basically only a marginal method. I would say it is only a starting method. And maybe I should have emphasized why you are trying to make this analysis of these methods. It will be important for you, and no matter whether you are someone who is working for the court and preparing the decision, or an attorney general appealing to this court, since you must know the methodology which is used by the respective court in order to be able to utilize it for your own purposes, since it is quite likely that the court will follow with this pattern in future cases. Well, and when it comes to grammatical method, the general approach to fundamental rights regulated by the Charter is that the Czech Constitutional Court simply and plainly notes the existence of such a right and the possibility of its impairment in the case at hand. The contents of the rights are then clarified using other methods of interpretation. And this has also some historical reasons related to the transition in law, which was done after the Velvet Revolution. We kept, in many situations, we kept the same statutes. The wording hasn't changed much, but we needed to deploy a completely different approach to the interpretation. And that was why the grammatical method was set aside, and why the Constitutional Court emphasizes more other methods of interpretation. Of course, when it comes to general courts, and especially courts of first instance, they tend to rely on grammatical method of interpretation more often, since, well, that's the easiest way how you can handle problems. Well, if it's written there, then the solution is, that's easy. You don't have to think about it much, usually. But when it comes to situations where the text is general broad, then of course this method of interpretation has its limits. The thing which is interesting is that when it comes to the European Court of Human Rights and grammatical method of interpretation, then well, there is one thing which you should remember. And that is that the European Convention, which is the law applied by the European Court of Human Rights, is subject to autonomous interpretation. And this is true also in case of EU law and the Court of Justice. So thus the words and terms used by the Convention or by the EU law do not have similar meaning as similar terms used by national law. And this is something you must be aware of and have to be very careful. In addition to that, both the Court of Justice and European Court of Human Rights have to do some additional steps, which are usually not necessary in case of your own national courts when interpreting the national law. And this is because they have to compare all language versions. It is easy in the case of European Court of Human Rights, but there are two versions only, French and English. Things get complicated in case of EU law, as there are 24 language versions. And it is necessary to compare all these language versions in order to identify the correct meaning of the text. And it is therefore true that what you see and read in a statute does not necessarily mean that it is actually contained in this statute. This can be demonstrated on a famous case, JUDr, in which the Court of Justice for the first time declared its readiness to protect fundamental rights. In this case, Germany, the German version of the legislation concerned stated that beneficiaries of a social aid may only receive the aid, other in this case, in exchange for a coupon issued in their names. You can see it on the slide. Other versions either supported this solution or contained a less strict requirement with no compulsory mention of a name. You can see it on the slide, for example, the French version stating bon individualisé. So the name was not a necessary condition. The coupon could have been individualized with some other method, ID number or something else. And the question is, we have one act which exists in back then in 4 language versions, now in 24 language versions. And what shall we do with it? Well, the answer of the Court of Justice was that you need to adopt a methodology which brings you to a uniform result. So you have to compare all the language versions. You cannot consider just one text in isolation of these others. You have to compare all the text. You have to reflect the purpose. You have to take into the account the other principles, principle of proportionality, the aim of the legislator. You have to take into account logical arguments and also the standard of human rights. And in the end, we can see that, the language versions, the statutes, the language may vary. We can see that in Germany, the coupon must have a name on it, but in the end, the name on a coupon is not a necessity. The reality in Germany was different from the text of the act at hand in German language. So this is something you don't do within we don't have to do it with our Czech law. We don't have to compare it with anything, but with EU law and with the European Convention, this might be a necessity. And you have to include it if it is relevant to your R section. Logical arguments usually have an auxiliary significance in interpretation of the law by the Constitutional Court and do not belong among arguments commonly used by the court. And the same is true in case of European Court of Human Rights and Court of Justice. The use of domestic systemic arguments is typical for the work of the Czech Constitutional Court. It is usual in cases where this court infers a certain conclusion on the basis of combination of several provisions of the Constitution and of the Charter. And this is typical, for example, for the Article 1, Section 2 of the Constitution, according to which the Czech Republic is to observe its international commitments. And this provision is often used in combination with other provisions, especially of the Charter. And this is how interpretation is found that conforms either to international law or to decisions of international courts. So this is not a matter of direct determination of the content of one provision on the basis of another, but the logic here is that the second provision opens the door for reflecting an external source, typically the European Convention, and this really is quite common. Another very common method for all three courts is the interpretation on the basis of past case law. And I would say that it represents the basic modus operandi of these courts. Basically, almost all the rulings of these courts comprises references to the previous case law. And at the same time, something that I would call a snowball effect is apparent in the decision making. And this is also very, you really can see it in almost every decisions of the Czech Constitutional Court. The conclusions of this court, which are in its previous decisions, are repeated in its new decisions. So new decisions are added to the original ones, and the later are quoted, and they are then later quoted together. So, and this ultimately creates the impression of a clearly and convincingly established case law and law. You use one case law in a subsequent case, then in a subsequent case you use the previous two cases as a supportive argument, and this is how you build, how the snowball is getting larger. This is how you build this argument, and it really creates an impression of something that is established, clear, settled. I would like to emphasize that the judgments of the Constitutional Court of the Czech Republic, and here this court resembles the European Court of Justice, lack any detailed analysis of facts in relation to the rule on the basis of which the decision was made. So here is the difference between us and between the United States. I have pointed out some similarities, but here this is different. The facts of the case, at least in case of the Constitutional Court of the Czech Republic, are often neglected. You just take the statement, the legal sentence, I would say, from a previous decision and apply it in future decisions without discussing the facts of the original decision. So in substance, for our Constitutional Court, it is typical that it merely constantly repeats its general conclusions until it creates quite convincing impression of a precedent, de facto precedent. Another type of arguments are external, systemic, or comparative law arguments. And I would say that external, systemic, and comparative law arguments are really the important ones in the reasoning of the Czech Constitutional Court. What is noteworthy is the way the Constitutional works with the text of international treaties in general, and specifically with the wording of the European Convention. In most decisions, the Czech Charter and the rights it protects were interpreted in the context of the European Convention and other international treaties. And even if the wording differs, you have the similar right in a Czech Charter and European Convention, but the wording may be different. So even if the wording differs, these differences are systematically overlooked, and there is a tendency to interpret the same rights in the same way. And the Court of Justice works usually in a similar manner with the European Convention. So that's not something typical just for the Constitutional Court of the Czech Republic. For the Czech Constitutional Court, it is also typical to reflect the decisions of other constitutional courts. When it comes to European Court of Human Rights and the use of its decisions in the case law of the Czech Constitutional Court, several basic approaches can be distinguished in this regard. First, the Constitutional Court mostly formulates its own opinion and refers to European Court of Human Rights case law in support of its arguments. It then uses the phrase, the Constitutional Court in conformity with, or the Constitutional Court agrees with, and then the decision of the European Court of Human Rights follows. Second, the Constitutional Court adopts a parallel approach, where it both interprets the Charter and repeats the conclusions following from the case law of the European Court of Human Rights. And the third approach could be described as borrowing or substitution. It is characteristic by citing the European Court of Human Rights case law without simultaneously considering the Czech law, which is thus assumed to be the same. And it is quite noteworthy that the position of the case law of the European Court of Human Rights is fully comparable to prior case law of the Czech Constitutional Court. The Czech Constitutional Court doesn't work like this, for example, with decisions of our ordinary or common law court or common courts. Their decisions may be questioned, but the decisions of the European Court of Human Rights are never questioned in decisions of the Czech Constitutional Court. I found just one exemption. Well, it may happen that if there is something the Czech Constitutional Court doesn't like about the case law of the European Court of Human Rights, well, it simply does not mention it. It's not wise to go into conflict, so it's better to avoid the conflict by pretending that something does not exist. But in all other cases, case law of the European Court of Human Rights is used in the same way as previous case law of the Court of Justice. And again, very little attention is paid to the facts the cases dealt by the European Court of Human Rights, but there are exemptions. In addition to that, the subsidiary nature of the European Court of Human Rights work is often overlooked. As is, for example, the fact that its decisions lack effect erga omnes. They are not precedents. They are not the binding law. But in practice, in Czech Republic, we use them like that. They are de facto precedents. The difference between a simple decision and a precedence is simply overlooked. Well, this approach was practical, at least in the beginning, since the Constitutional Court as a young tribunal lacked its own history and methodology, so it simply borrowed someone else's methodology and case law. And at the same time, it allows the tribunal to support its own authority, because a conclusion made by somebody higher, by the European Court of Human Rights, must inherently be correct. Another important method is comparative interpretation. And this is very interesting, since it is quite fragment method of interpreting the Czech Constitutional Court. It is quite fragment in its case law. However, comparative arguments as used by the Constitutional Court have nothing to do with comparison as a scientific method. These are two completely different categories. Indeed, the comparison as carried out by the Constitutional Court never goes beyond a mere statement. The situation in another country is such and such, similar or the same as here. There is also a tendency to highlight only those states and those cases which are in favor of a conclusion to which the Czech Constitutional Court wants to reach. You may sometimes notice the comparative interpretation also in the case law of the European Court of Human Rights and Court of Justice, but they are not common methods of interpretation. Another important method of interpretation is teleological interpretation. This is an important method used by the Czech Constitutional Court. However, similarly to linguistic interpretation, it is only rarely expressly admitted. But this method is really typical for the Court of Justice. especially together with the principle which is known as ECtHR, the effectiveness principle. You know, that's the principle according to which the way of interpretation which brings us to the result, you know, which works, should be preferred over those options that are not effective, that do not work. And in case of the Court of Justice, this maxim is used to its maximum effect. You know, the Court of Justice asks for maximum possible effect and maximum possible and to it related way of interpretation. Something that is really interesting is the argumentation which is based on jurisprudence and on scholarly works. This is something that is really frequent in the case law of the Constitutional Court of the Czech Republic. This court often cites scientific literature. It often cites also literature of a philosophical nature, and sometimes even literature which has nothing to do with law at all. Czech students probably would know the Czech author Hašek and his novel Švejk, Příběhy dobrého vojáka Švejka. And this novel, you know, you can find some decisions of the Constitutional Court in which this novel was cited and worked with. Which is, you know, this shows us that, you know, judges are also people and makes the decisions of this court more personal. But I would say that, you know, the utilization of this method is, in general, rather problematic in case of the Czech Constitutional Court, since it often refers to publications which were authored or co-authored by one of its justices, or to those which were written by their colleagues or friends, which is somehow funny, you know. The court uses scientific literature in support of its own arguments. However, it was a member of the panel who actually wrote the article, so he's supporting his own arguments, and that's not fair, I would say. You know, once even an unpublished book was cited by a panel, and the co-author of this book was a member of this panel. So the selection of literature can hardly be considered objective, but one can see that lately the justices are aware of the problem and trying to avoid it. And here there is a huge difference between Constitutional Court on one side and European Court of Human Rights and Court of Justice. They never refer to scientific literature. This is a huge difference. Well, the question is why? I would say that most likely it is because of the fact that the scientific literature is usually related to a certain state. An author comes from a certain state and it is influenced by a certain way of thinking, by a certain way of legal culture, and you know, these courts are most likely trying to pretend that they are objective and autonomous on national legal systems and on states. Well, and the last I would like to mention is interpretation in light of general principles. This is quite common in case of Court of Justice, as these legal principles serve as a tool. The Court of Justice used them in order to be able to support its view of the European Union as of a third autonomous system of law, the EU law as an independent law, international and national law. And when it comes to concepts and specifics, there is one that distinguishes the European Court of Human Rights from the other two courts, and that is the doctrine of margin of appreciation. This concept refers to the space for maneuver that the European Court of Human Rights is willing to grant or has to grant to national authorities. So it doesn't necessarily feel to regulate every little aspect of the problems which were submitted to it by individuals, from members of Council of Europe. That's something you won't find in case of Constitutional Court and in case of Court of Justice. And the European Court of Human Rights and Constitutional Court have in common the subsidiary role in protection of human rights. So they are doing something that it should be primarily done by other, let's say, lower or common courts. Well, and I've said already that the European Court of Human Rights and the Court of Justice have in common the concept of autonomous interpretation, which does not extend to the Constitutional Court of the Czech Republic and the Constitution. So, by using these methods and knowing how they are used by your courts, you can work with the R section in your analysis, and your chances that you will come to a conclusion which will be successful rising. Well, I've been speaking for quite a time now, which means that I should end. And here are some tips if you want to know more about judicial reasoning. The first is publication, which is going to be published and which focuses specifically on the judicial reasoning in the area of Central Europe. And the second publication is an older publication which includes also some constitutional courts from other regions of world, as for example, Canada, United States, or Australia. Well, and these are the references I have used in order to prepare for my lecture. And that's it. Thank you for your attention.